That's correct. So you issued an opinion where one of the litigants before you was the president and in favor of the president while you were in active conversation with the senator's office about seeking a federal judicial appointment. Is that correct?
For a position I did not, in fact, get, Senator.
How did you end up in front of me today?
It's a different position, Senator.
Did you consider recusing yourself from that particular decision?
No, and the canons that govern us in Florida, Senator, as I believe this committee has previously heard, it did not call for me to recuse myself. I did not have an interest in the litigation, and none of the basis called for recusal, and the Florida Supreme Court instructs us, the appellate judges, that we are not to recuse unless one of the bases in Canon 3 exists.
Does the Florida canons not require you to recuse if one of the parties before you has an interest that could be reasonably concluded by any common citizen to cloud your judgment on that matter?
Senator, I disagree with that characterization. I had not heard from the White House until after the opinion was final. I had only spoken.
When did you interview with the White House counsel's office?
At the end of February of 2025. I don't know the date, but I believe it's in my Senate Judiciary.
How did you end up in front of me today? That is the exact moment Senator Chris Coons catches a Trump nominee dead to rights in a massive conflict of interest, making his excuses crumble in under half a minute. Chris Coons just delivered a crushing blow at the Senate hearing, unmasking a panel of Donald Trump's judicial nominees who are either covering up a shady timeline or are simply too terrified to affirm the U.S. Constitution. We are talking about a Trump nominee, an appellate judge who just signed off on a ruling favoring Donald Trump and a mere few days later proudly strolled into the White House counsel's office for a promotion interview. This goes way beyond a political squabble. This is a terrifying reflection of a justice system where Trump nominees are turning the courts into a personal favor factory. When Senator Chris Coons unleashes a stack of documents to interrogate this timeline, the nominee's only way out is to play word games about which specific position he was actually applying for. However, Coons doesn't pull his punches, and the story doesn't end there. Coons continues to expose the other Trump nominees in the room, who stand paralyzed by cowardice when questioned about a fundamental, unalterable pillar of the law. Stick around until the very end, because the moment this panel is asked whether the president has the right to run for a third term is a classic masterclass in how Chris Coons corners officials who deny the supreme law of the land. Hit the subscribe button now, because when legal justice starts mutating into a reward for submission, you desperately need to witness these undeniable receipts with your own eyes.
Senator Coons.
Thank you, Chairman Grassley, and to each of you and your families, congratulations. And thank you for raising your hand to serve and in some cases continuing to serve the public.
Thank you.
Mr. Mark, if I might, just tell me about the 22nd Amendment. What does it provide?
The 22nd Amendment, Senator, my career has mostly been in criminal prosecution. I haven't had an opportunity to use that one specifically.
Anyone able to help on the 22nd Amendment to the United States Constitution?
Well, Senator, I believe it is the amendment that deals with a two-term limitation on
Correct.
the service
It
of the
states
president.
no person shall be elected to the office of the president more than twice. Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be.
It's not a hypothetical. Has President Trump been elected president twice?
President Trump has been certified the President of the United States 2 times.
Is he eligible to run for a third term under our Constitution?
I would have to review the
All I need to
actual
tell
wording
you
of
is
it.
the language of the constitutional amendment that makes it clear that no, he is not eligible to run for a third term. Anybody else brave enough to say that the Constitution of the United States prevents President Trump from seeking a third term?
Nobody pay close attention to the tactic used here. Chris Coons doesn't resort to convoluted trap questions. He directly enters the clear-cut text of the U.S. Constitution into the record as the most ironclad receipt. The 22nd Amendment is absolutely not a complex piece of case law. It is a stark, black-and-white mathematical rule. It explicitly states that no individual is permitted to be elected president more than twice. The receipt Chris Coons is holding is the certified reality that Donald Trump has won 2 elections. Yet, look at how the Trump nominee, Mr. Mark, struggles to cover his tracks. First, he uses his criminal prosecution background as an excuse to dodge. Next, his legal strategy is to evade an absolute constitutional truth by labeling it a hypothetical while pretending he needs to reevaluate the facts of an event that has plainly already happened, and when Coons throws cold water on them. Is anyone in this room brave enough to apply the Constitution? The room sinks into a chilling, dead silence. This is the art of exposing those who seem untouchable. You reveal the truth that those entrusted to protect the law refuse to enforce it if the answer threatens to displease their boss. But if you thought the silence over the 22nd Amendment was the absolute worst of it, let's look back at the shocking timeline of Judge Coons.
Is it pronounced the same way mine is? Or
Yes, it
Coons?
is. Yes, Senator.
My family's name was spelled that way when we came to the country. So, you were one of 3 judges on the panel in Alexander v. Trump, where the president was suing the Pulitzer Prize Board for defamation. When did your work on that case begin? When were you assigned this case to decide?
I first learned of that case in approximately January of 2025.
Not when the briefs had been filed?
No, Senator. The way it works in our court is we are not assigned cases when the briefs are filed. Once the case is ready for disposition, the clerk randomly assigns it to the judges in the court.
And when did you first speak to Senator Scott's office about your interest in a district court seat in the Southern District of Florida?
I mean, I've had many conversations with Senator Scott's office. The one about an interest in the Southern District of Florida, I believe, was in November of 2024. I don't know the date, but it's in my Senate Judiciary questionnaire.
And when did you release the opinion ruling in President Trump's favor in this matter?
So I learned of the case in January of 2025, and the opinion was released in, I believe it was February 12th, 2025.
Let's review this razor-sharp mountain of receipts that Chris Coons just laid out. Back in November 2024, this judge was aggressively lobbying a Republican senator's office to secure a federal seat. By January 2025, he is randomly assigned to handle a defamation lawsuit with Donald Trump as the plaintiff. By February 12, 2025, he officially signs a ruling in favor of Donald Trump. Instead of providing a legally sound explanation for this ethical dark spot, the Trump nominee tries to hide behind state-level regulations to excuse why he refused to recuse himself from the case. Let's see what unfolds next.
Did you consider recusing yourself from that particular decision?
No, and the canons that govern us in Florida, Senator, as I believe this committee has previously heard, it did not call for me to recuse myself. I did not have an interest in the litigation, and none of the basis called for recusal, and the Florida Supreme Court instructs us, the appellate judges, that we are not to recuse unless one of the bases in Canon 3 exists.
Does the Florida canons not require you to recuse if one of the parties before you has an interest that could be reasonably concluded by any common citizen to cloud your judgment on that matter?
Senator, I disagree with that characterization. I had not heard from the White House until after the opinion was final. I had only spoken.
When did you interview with the White House counsel's office?
At the end of February of 2025. I don't know the date, but I believe it's in my Senate Judiciary.
The facade of impartiality has been completely torn down. An appellate judge, who also happens to be a Trump nominee, signs a ruling benefiting the president on February 12th, just a few short days later. At the end of February, he casually shows up at the White House counsel's office for a job interview. This is the very root cause of why the power elite always fears transparency. When a nominee leans on Canon 3 to justify auditioning for a promotion right while presiding over his boss's case, he is essentially turning the sanctity of the law into his own personal shield. But perhaps the most agonizing blind spot of this entire hearing lies in how Trump's nominees can fluently recite multi-layered legal jargon by heart, yet stay as quiet as a mouse when asked to stand their ground against the executive branch. Watch how Chris Coons tests Mr. Hendershot with basic legal theory before casting his final net.
Judiciary questionnaire.
Thank you for your testimony on that matter. Mr. Hendershot, if you would just take a minute and talk me through again how collateral estoppel and res judicata are different from each other.
Senator, I'm not sure I can improve much on Judge Coons. I think that often res judicata today is used as sort of a catch-all term, but generally I think the difference is between claims and claims that may have not been brought but could have been brought potentially.
Right.
So collateral estoppel and res judicata is more of a thing actually decided, as the Latin would suggest.
Thank you. Do you agree that judges should not be influenced by external pressure to rule in any particular way?
Yes, Senator, I do.
President Trump stated March of this year at a public event, quote, "We have rogue judges that are criminals. They're criminals, what they do to our country, the decisions they hand down and hurt our country. Is it possible for a judge's decision to be correct as a matter of fact and law, even if it differs from the president's desired outcome?"
Senator, I want to tread carefully because of Canon 5 in terms of commenting on political matters. But in the abstract, yes, decisions can be corrected, and any citizen can criticize what a judge has done. That is, I think, part of their right to speak.
Thank you. Thank you all for your testimony.
Yeah.
I want to tread carefully. That utterance alone strips bare the entire problem with the Trump nominees. Mr. Hendershot has no trouble at all boldly explaining the Latin origins of res judicata or dissecting the meaning of collateral estoppel. They appear as erudite scholars when the law is confined to black ink on white paper and doesn't step on any toes, but the exact second Chris Coons quotes Donald Trump word for word smearing judges as criminals and poses the highly fundamental question: can a judge be legally correct even if the president despises the outcome? All professional demeanor instantly evaporates. Instead of a resounding yes, this nominee recoils. He is forced to tread carefully. He takes refuge behind Canon 5. He only dares to nod in the abstract, when a public official must timidly weigh every word. Just to acknowledge that the law is not subject to the president's fury, he is exposing a machine completely dominated by fear. The truth here is incredibly straightforward. Accountability gets suffocated in the dark corners of backdoor deals drawn up under shady timelines, whether it's the image of a room packed with Trump nominees, afraid to acknowledge the two-term limit of the 22nd Amendment, or a judge ruling on a defamation case only to interview for a federal job from that very same administration days later. What we are witnessing is the privatization of the judiciary. They are systematically transforming federal courts into a private security force for the elites. Share your thoughts in the comments section. Should we allow a judge to rule in favor of a president only to strut into the White House for a job interview a few weeks later? And does the coping mechanism of these Trump nominees dodging the Constitution and treading lightly around basic truths convince you to trust in the rule of law? Let's unmask the individuals who dare to trample the Constitution for partisan gain. Don't forget to like, subscribe to the channel, and spread this video because the truth always needs to be exposed through ironclad receipts. See you in the next videos.